начинать. Я понимаю, что вчера был вечер Legal Drink. У нас мы сильно не досчитали существенной части аудитории, но тем не менее самые крепкие, самые стойкие у нас уже здесь. Остальные, я уверена, к нам подойдут. Нас очень просили не торопиться с этим организаторы форума, потому что сейчас из последних сил собирается юридическая общественность. Но тем не менее у нас замечательный такой.
Yes, now we see that more and more people are going to join us, and we have excellent speakers here today. I don't think that we need to wait any longer, although we were requested not to start very early by the organizers. If you don't mind, I will be presenting our speakers one by one just before they start giving their presentation. Our today's discussion will be devoted to a very interesting topic. We all understand how complicated and extremely informative for lawyers it might be, because this time we are living in is really interesting. There are so many challenges in the Russian society and in the world situation of global recession. Russia is in a sort of unique situation, and yesterday I attended several panel discussions devoted to it. But we should say, and we probably honestly can say, that all issues and all problems of the Russian law and international jurisdictions, they are similar in most ways. We live at the time of integration, globalization of markets, and mutual penetration and interrelation of market institutions. And that is why any commercial activity, any transaction, property management, cash flows are under the risks of several jurisdictions, and very often there are dozens of them. And we understand very well that the standards the society imposes in the area of financial transparency depends on a number of factors, and we observe this, and we are observing these different cultures. And we see that the stock market was developing in a certain way. At the same time, taking into account these different cultures, but international standards of the financial community are the same, and companies operating in large economies, they have to support and follow those standards. And within the past 20 years, when we see that the world standards have been changed, and all these transparency and clarity of transactions, this is a compulsory requirement now. And we see that there's really a serious pressure onto Southeast Asia. We understand it very well. We realize that their culture of market organization is quite different from what is required from them by the international community. Now we see that Singapore is changing, is adjusting a lot, and it will be a bridge between the Asian markets and Western markets. And I have seen Chinese colleagues. We communicated yesterday with them, and they are selecting for the laws that will ensure law enforcement procedures, and they are looking at the British legislation and Singapore as well, because Singapore is developing one of the toughest laws in the world, but for them it is a prerequisite to become a fully fledged participant of the financial market. Looking at the historical perspective, we can recall that 20 years ago we were living in a different world, and when I started working, if anyone would mention that the Swiss market will have volatility, I would laugh probably, but we remember how dramatic the 90s were for the Swiss banks. Later, the confidentiality of bank transactions, that was an important issue, and now there's a big question mark whether this confidentiality exists in this sphere. We remember that at the very beginning of this century, last decade, this market observed those strict controls, and the United States interfered a lot because there was a terrorism threat, and we remember that SWIFT system is under control of the United States prosecution bodies. Let's use these wide terms for that. And we all are in this understandable situation, and we have lots of concerns and issues. We know that Cyprus has been through this comprehensive reform, and all states, this way or another, they have to adjust and adapt their work for these international standards, which are not always comfortable for them. At the same time, we understand that the states want to be most attractive for investments, especially in these hard times. Big money likes quiet places, so it likes to be in a quiet and dark place. And it's a fact now, and we have to accept it, that all jurisdictions are a bit myopic when a lot of money joins the market. Russia is undergoing these serious changes. We are making big steps towards transparency and determining actual beneficiaries of all transactions, and we have been working a lot in this area, and everyone is a little bit nervous because revealing the names of the actual beneficiaries in relation to specific properties, this might involve risks. And this discussion will be devoted to the balance and coordination between these compliance and transparency requirements and market attractiveness, which is usually determined by freedom, flexibility, and the corporate curtain, which usually hides lots of things, including the actual beneficiaries. And before I give the floor to the speakers, I would like to give the floor to the General Director of LexisNexis of Russia and Eastern Europe, and a good friend of Russia. This is Iacono Gandolfo, and I requested him to speak about compliance standards and the overview of this practice, because LexisNexis is analyzing this on a large scale. Thank you very much, Natalya, for this proposal. Esteemed colleagues, I'm very happy to be here and speak in this audience. I would like to speak in Russian, but my level of Russian is not so high, and if you don't mind, I will continue in English.
As Natalya has mentioned, my name is Gandolfo Iacono. As you can imagine from the name, I'm Italian, but I have actually Iranian origin from my mother's side. And I lived in United States, continental Europe, Netherlands, and I'm here in Russia for 5 years. So what I can tell you that I want to highlight what Natalya was mentioning, that is colossal steps in terms of financial transparency. And I can say that that is true. Here we are going through that kind of very high level. I was just introducing myself to tell you that there is an international route when we speak about financial crime. And that means that in order to combat financial crime, we need to have a certain kind of, I would say, common approach. And that means two words, and is financial transparency and financial governance. Because we have different authority looking at the issue, and from different countries. So harmonization is one of the key factors. As Natasha mentioned, here we have a few information about LexisNexis. We have opened the company in Russia 5 years ago. I will focus in, let's say, some odd topics that are the KYC, Know Your Customer compliance, then IML versus data protection, and the culture of compliance. Of course, there are some other topics like virtual currency or what is called the risking. That of course, there are also odd topics, but in 10 minutes we need to focus in something. So I decided to look after topics that are very close to LexisNexis and what we deliver. The first concept is what is KYC? So basically the concept is understanding the nature of the customer risk profile and relationship. So that is nothing new. That is really is based on a process. So there is a process we need to follow. You need to follow as a bank, as a corporation, that goes from the customer identification program, so onboarding process for new customer, and that means due diligence investigation with initial verification of identity, risk assessment, profiling of potential client. The second step would be the simplified due diligence. That basically is verifying identity and assessing the risk of the customer. That is based on risk-based approach and third-part risk. Then, of course, we have the transaction monitoring. So ongoing identification and reporting of suspicious activity from customer transaction data. And the EDD, enhanced due diligence, verifying identity and purpose of the account for high-risk customers. And here we open another kind of big theme that is beneficial ownership and type of business. Just few days ago, beneficial ownership is a hot topic in Russia, is everywhere a hot topic. The European Parliament adopted the fourth anti-money laundering directive, and one of the most salient element is the introduction of a publicly accessible register in which the personal information of the ultimate beneficial owners of corporate and other legal entities would be included. It goes without saying that the above has far-reaching consequences for the privacy of beneficiary owners of EU entities. And of course, EU members such as Cyprus, Luxembourg, Malta, and Netherlands shall have 2 years to adopt the directive in their national legislation. So that is, of course, is something that is there will be a lot of discussion, especially about how to implement this. But that is really, another step further to compact financial crime. As I said, I have mentioned many times the word risk. And we have a counterparty due diligence workflow. So basically, that is the process that each bank has in place, but also each corporation needs to have in place. And it's a very simple system. I mean, it's simple on the graph. Then to apply on the daily life, then it becomes a bit more complex. But again, you see, there is a process in place that basically goes from simplified due diligence, but the main concept is risk. So the concept is what is the appetite of risk from a corporate, from a bank. And basically, we assess the risk in 4 areas. So the first one is the jurisdiction. So basically, we are operating in Russia. If there is a company that is registered in BVI, we would say that for us, doing business with this company is high. So we need to do enhanced due diligence. If the company is registered in Russia as a Russian company, we would say that that is not a red flag. Then there are services. So which service the company is providing? We know that there are some services in which there might be heavier risk of crime. It might be, for example, we know that we look very carefully construction. The entity is a public company, is a private company, and you can put your risk flag. And then you have the value. What is the value of the contract? Of course, you can decide, if you have a contract that is, or a customer, and we are speaking about $100,000, and you have another customer that is $1 million, of course your risk approach needs to be different. So basically from simplified due diligence, that means simply ID verification data, sanction and watch list, check, political exposed person, check, in-house do not business with, check, and negative news. If one of 2 of these risks are red flag, then you should go through the enhanced due diligence. That basically it's perform a deep investigation on not only on the company, but on directors, subsidiaries, contractors, and other associates across. So that means that you need to do the job you have done on simplified due diligence also for all these entities. True, the global media, we don't use anymore national media because we understand that in order to have the full picture, it's global. And we need to go global because shareholders, affiliates usually are outside of the country we are looking at, of the company. So basically we do this on a global media, ID verification data, sanction and watch list again, company information, and legal cases history. Now, once you have assessed all this, and you say, well, this customer can go, we can do business with, that goes on transaction monitoring. So basically, imagine you have 5,000 customers. You cannot do manually each day a check what's going on with you, with your customer, with your supplier, with your reseller. So basically, you need to have in place a system that allows you to screen all your customers automatically. And once a risk it has been identified, again, so you have not identified at the opening of the accounts, but eventually it comes after there is a problem, then you need again to do all this process. The customer or the supplier needs to go through the third-party database in what we call in a special interest media monitoring. Basically, it's automatically monitoring and analysis of global entities of special interest. And that means effective insight of market opportunity and reputational risk. So basically, you need to have, technology. You need to have a support services. Well, we have the LexisNexis content. You need to have web sources. Of course, social media, because today we know that a lot is going through social media. So monitoring of Facebook, monitoring of contact and so on needs to be there. So that basically is the tool that we use as a company in order to screen counterparty. And that is the model that basically banks and corporations they look after worldwide. As I said before, here there are SDD. It means simplified due diligence. Then we are speaking about enhanced due diligence. We do many conferences in Russia on this topic, and they always, and they say, well, how do? You do simplified due diligence or more enhanced due diligence. So what is the right proportion? So where there is no a recipe here, because it's based on your risk approach. But as a company, as we do here in Russia, basically we have 100% of our customer are screened as simplified due diligence. Then we put this in transaction monitoring. And then I have a proportion, 20% of this company that might be classified, so we classify as high risk, are processed for the enhanced due diligence. So basically, we really go deep on studying the structure of the company, affiliation, subsidiaries, and so on. And that goes on 20%. Now, this statistics is related on 2014. Now, what I see in 2015, the level of enhanced due diligence for our business unit in Russia is going up to already 30-35%, and that is to the current climate regarding sanction. Because with sanction, we need to basically check the structure of the shareholders, and that requires enhanced due diligence. One of the main issues that we see in terms of KYC is data protection. Especially in Europe, that is really an issue. And by default, if we read the definition of what is KYC and what is data protection, you will see right away that unfortunately, there is no a convergence. Actually, they are going exactly in the opposite direction. Because if you look at the KYC, the principle is collect all the necessary data in order to minimize the risk of doing business. And if you look, the concept of data protection is collect minimum information for processing of data. KYC, identifying and verifying the identity of customers and the nature and purpose of customer relations. And data protection say, well, you need to have consent and eventually security requirements. Then identifying, KYC, identifying and verifying the identity of beneficial owners. And then the data protection say, well, prohibition in the use and transfer of data such as criminal, medical, credit report, political affiliation, real estate, etc. And then we go again back to KYC. Conducting ongoing monitoring to maintain and update customer information and to identify and report suspicious transaction. And another, sharing of customer data is based on a risk approach. And if you look at data protection, is international data transfer restriction. So you see, that is quite a challenge for who is working with AML. So, and there is no, it's something going on because in Europe it's becoming really a focus point in the last 2 years. So we will see. And the last point I wanted to cover is the culture of compliance. Because of course, you can have all the possible models, you can do all the screen you want, but at the end of the day, if there is not a risk-based approach, and especially a culture of compliance, the organization will not go further. The culture of compliance, of course, is based on tone from the top. So it's clear that the CEO or the board of directors, they needs to have a clear understanding of what is financial transparency and how to implement it. Because if there is no the tone from the top, we have seen there is no really great results. Then the other important point is the involvement of senior management. And usually, the question is, can compliance be considered something different than the label of a cost center? Because of course, compliance has a cost and is increasing. So, and the point, when I speak with my colleagues, director of AML, director of compliance department, I always invite them to try to involve as much as I can in their discussion senior management, because there is no way they can pursue what they want if they don't have the involvement of colleagues. And then there is a new issue coming out in the last year, is accountability of compliance officer. There is a lot of discussion around, and in the United States, there was some months ago in a conference, and there was somebody saying, "Well, you see, the compliance officer should be, if he's not doing the right job, it can be considered as a criminal offences." And that is a quite. There is a lot of discussion going now, because you see, if you are a compliance officer, and you see that your organization is not supporting your view, if you risk a criminal investigation or you risk, something that is beyond the power of the company, then you really need to think to leave the company, to leave the banks where you're working, or to leave the corporation you are working, because there is no a culture of compliance. So, and right now I was saying, well, till that will not be a criminal liability, then there is no need to change the company. You will just stick there. And then the other point is to who the compliance officer needs to report. Which kind of system they might be put together in order to support the work of the compliance officer. So that are really hot topics, and actually they were already hot topics. They have been always hot topics. They will continue to be hot topics, because I would say the criminal economic crisis, economic crime is becoming more and more sophisticated. So thank you very much. So I hope it was interesting, and maybe we'll have a question a bit later. Thank you.
I guess that's why all the banks. I guess that's why all the banks.
Да, наверное, именно
Members of their compliance department, aren't they? So I guess that's the reason you're talking about. Павел Ильич.
Огромное спасибо. Слышно?
Can you hear me? So, am I on? Gandalfa, thank you so much for your most interesting presentation. I was especially interested as a representative of financial intelligence. So I am the consumer, or a consumer, of the information generated by Compliance Department of Financial Organizations. So for me, of special interest, there were two of your points. First off, you have described a most interesting picture of working with the client based upon the principle of separating the risks. You have drawn an ideal picture of applying proper ways of working with a client. I have to say that in many jurisdictions, this stops at identifying your customer, which is especially typical for small and mid-sized banks. Large banks in Russia, too, are digging deeper and deeper into analyzing the client, understanding his business history, knowing their counteragents and their real economic activities. So with this regard, I have a question, please. There are two ways of working with your customer which are especially risk-bearing. The first way is putting barriers in the way of their economic development. You may refuse an agreement of banking services to such customers, and if we are talking a non-banking organization, but for example an agreement for security purchase, you may prohibit a customer to do certain transactions before additional information is found. And finally, you can terminate a business agreement with them. You can stop any relationships with them. This culture is well developed in many states where the British legal system is applied. Russia has converted to this practice back in 2013. We can see that the banks take an active advantage of this system. We are using the accrual principle since December 2013, and we have given about 25, we have rejected 25,000 customers, and we have about 40,000 rejections for specific transactions, and we have several thousand of terminated agreements, which is probably good. These are good numbers. And there is another way, probably very much liked by any financial intelligence officer. That's when a credit organization follows up a suspicious customer, accumulating a sufficient body of evidence, and then there is a lawsuit filed, the dossier is passed over, submitted to financial intelligence, and they take care of it, and then they give it over to law enforcement. This may be a much more difficult way, and it's much more risky for a credit institution, for a financial institution. And this way may also be very risky for economics, because if there is a customer doing some illegitimate transactions, this may be risk-bearing for the national economy. But once a customer is evicted from the economic activity, it doesn't mean that he disappears. His assets do not disappear. They may flow over to some poorly regulated sectors. They may go into grey cash market or black cash market. They may flow over to the criminal work. And also, FATF is now paying attention to the de-risking problems. That's when financial institutions get insured, and after the first call, they get rid of the risky or suspicious customers, and those customers may be quite law-abiding, and that kills the reputation of a customer. So this is quite a contradiction, and I would very much like to hear what you have to say with this regard.
This is quite interesting because you see, it's again when we speak about the risking, it's there was recently a questionnaire that from the ACAMS, that is one of the organizations that is overlooking, AML, and basically the question, are you ready to the risking? And basically there was. Yes was like 20%, no around 20%, and then all the rest depends on the case. So it's again related to the risk approach. And another issue is another issue. Another issue is how local legislation is supporting the risking. How local legislation is supporting AML and compliance, because again, that goes again to corporate governance, because different authority, they might want different, they have different tasks, different aims. So that is again the issue we will face. So there is, I don't have really an answer, but again, there is a risk approach that is fundamental. And what I see right now that in Russia and in other jurisdictions, there has been a lot of enforcement, and a lot more will come. So the risk appetite is, I would say, going, I mean, the companies, they are doing, or banks, they are doing more and more enhanced due diligence.
Gandalf, если позволишь, я еще...
Gandalf, I have yet another question to ask of you, if I may. Of course, we are not financial intelligence, but for many years we are restructuring transactions and increasing the safety of transactions. So we have to face due diligence very often in our work. So when we look at a due diligence summary, regardless whether it's an in-depth due diligence or a simplified due diligence, very often we have to work with a de lege lati and de lege ferende. Let me give you an example. Let us take a transaction of real property purchase with VAT refund. After each such case, there is a criminal case following suit. You know, this is the Russian practice. And there is also always a good, nice due diligence result from a reputable company, and that says that VAT is refundable under the Russian law, so it can be reimbursed. And if this is the case, and that's true, the Russian law allows for that. But if we check the structure of a transaction and the real cause of the transaction, we can see that the law enforcement bodies will see some signs of illegitimate activities targeting specifically VAT refund. So what shall we do in a situation when we have a certain practical experience, which is not always straightforward, and there are some legislatory possibilities, some legal norms that are of dispositional nature. It largely refers to structuring transactions, and yesterday it was discussed in detail by one of the panels dealing with mergers and acquisitions, and we know that M&A transactions number has decreased by 50% last year alone in Russia. Any comment? Could you please...
Question from, because my background is mostly economic and financial crime, so I can give you an example. There is a business case that is going on still, is about a company called Finmeccanica that, you know, it was involved in seems in a corruption case, is an international. So basically it's an Italian company. It seems that the corruption was done by the UK company, and that it seems that the corruption took place in India. So you see, you have involved 4 countries with different, legal system. It seems that from the corruption took place through a company that is based in Mauritius. So there is a 5th element there, and you see, it's very complex. And the point is that there was during the investigation. The prosecutor said that there was a tape recording in which 2 of the people investigated were speaking by phone. And one said, look, we opened the company in Mauritius because even if there is an investigation or if there is an order of disclosing who are the beneficiary or the beneficiary owners, it will take 2 years to get this information. Yeah? That is the issue. And that is, again, goes back to the risk factor, because there are some jurisdictions in which you know by default that if something happens, you will not have the information you need at the right time. And the issue is, in that 2 years, you can eventually go after the beneficiary owners, but 100% you will not find the assets. So basically, you are doing everything you can, but on that time frame, the assets are not anymore there.
Thank you very much. Если у нас нет вопросов, я...
If there are no more questions, I believe it would be quite logical to move over to Vasily Anatolievich's speech, and later we will have a Q&A session. Okay, let's move over. The floor is given to Vasily Pozneshev, Deputy Governor, the Bank of Russia. Actually, he represents the body which regulates the sphere we are discussing.
сейчас пробую.
Okay, is it on? Is it working? Very good. Good morning, everyone, dear colleagues. I would like to share with you our observations, and actually we accumulate them in the course of our work. I'm responsible for the banking control and supervision in Russia. And definitely the topic of financial crimes is of great importance. We face financial crimes quite often, and the reason for it is pretty obvious. The banking sphere, the banking sector, is very susceptible to what is called financial crime in our practice and internationally, because the bank is probably the only organization that has a professional license issued by the state to work with money that it receives from people and companies, and banks may work with these accounts in any form, cash or non-cash, in any hard currency and whatever. And the banking system is the only system that allows practically instantly, and actually it is the speed of light, yeah, because all this is done through optic fiber cabling, so we can transfer the money or assets of one person, of one company to another, and it can be done in any jurisdiction. That is why the banking system should be monitored and controlled. I would like to cover not only the traditional side of this, and actually we have already started discussing it. The traditional, I mean financial crime related to anti-money laundering legislation, and my colleague from the financial monitoring service, Pavel Levadny, will be speaking about this. But we come across it quite often. We identify in various banks certain facts of money laundering or strange transactions abroad, and also what we call illegal transportation of cash. There's another side to it, and it is not so well covered and discussed at various forums and meetings, but it is equally important. In the course of our monitoring work, you probably know that last year the Bank of Russia called away 86 licenses of various banks. So it means that these banks couldn't continue their operation. And this year it has been already 24 licenses. And when we analyze the reasons for this, we see that together with the issues related to money laundering and violation of legislation, laws in this sphere, there were also certain actions that we classify and must be classified as financial crimes. So what do I mean? First of all, it is fraud of documents, of any type of documents, chartered documents, financial documents of legal entities and physical persons. You probably know what fraud reports of salaries of people are, and there can be falsified certificates from the depository, and it may confirm availability of certain stock assets which don't exist, and then falsification of financial reports, which is sometimes confirmed by auditors. Even this occurs. Then giving loans to companies or people who will never return it, and then they give out another loan to service the previous loan. Then special schemes with sometimes participation of international advisors in order to increase the capital of companies, and often it banks from other jurisdictions and non-residents are participating in this. Then various questionable transactions with securities and derivatives, so that to modify profit and revenues of the company. Then some wrong assessment of the pledge value, and very often all these papers are verified by professional assessors, although they have been falsified. And as a result, the Bank of Russia receives some modified and adjusted reporting. So why I am speaking about all this, why I'm referring to these facts, we do understand that if there is a good compliance system with all technical support, it is not sufficient. All these factors, and I'm referring to this second group of crimes and fraud, there's not only an objective element, but also a subjective element. It is intention of the people who did it. All these offenses are impossible without full understanding of the owners and top management of these banks, what they do and what their employees do. And for a long time, we have been trying to determine and give a definition of this subjective element in our normative acts, and it was introduced last year, and we wanted to increase liability of the top management of banking organizations in relation to providing false information and frauding. And as of 1st of July 2014, Law 218, the federal law, became effective, and this law introduces changes into the criminal code. It now includes a new offense, which is a provision of false financial reports. In particular, inclusion of incomplete and false data, then verification of these data, publication and making this data open, and providing wrong financial information to the Bank of Russia. And this is Article 172. And there's certain penalties for this, starting from a fine of 300,000 rubles up to 1 million rubles, or the salary of the person responsible for this for 2 to 4 years, and up to imprisonment, 4-year imprisonment. These norms have just been introduced, and the law enforcement practice will be closely monitored by our organization, and probably the practice will its practical implementation will demonstrate that there should be revisions of these procedures. And of course, every fact that we identify, we transfer them to law enforcement organizations, and there's a number of lawsuits already, and they are at a different stage of consideration, and we are closely monitoring them. We really believe that inclusion of this offense and measures to punish for it is a significant step forward, and it will allow us to diminish the number of such crimes. As for our future work and analysis and inclusion of the international experience, what we would like to draw our attention to, I have already mentioned assessment, asset assessment practices. Very often, these assessments take place several times, and all these values are verified by international assessors. And we believe that the regulator should have the right to assess the pledge and assets of the company on our own. So now this requirement or this right is not clearly outlined. So we would like, in a situation when we suspect that something is suspicious in terms of value and assessment of this value, we would like to do something. But right now we cannot make them change this value and their balance sheet, because right now international standards give the right to the accounts to determine so-called fair value of assets. This concerns not only property but also the whole spectrum of assets apart from loans. Loans are assessed via reserves, but everything related to bonds, obligations, shares and stock, everything related to shares in various funds, closed funds, everything related to derivatives, this can be assessed, and we can determine its fair value. The question is about fairness of this value. So those numbers that are included into the balance sheet, the big question mark is whether it has something to do with reality. So we are now developing our normative base, and we try to define procedures and requirements to such assessment, and we hope we will have an opportunity to advise banks to modify these numbers. And the Bank of Russia currently has no right to see the pledge, the properties which is provided as a pledge. This can be done only when the customer and the client allows us to do it. So the bank sees the documents, so all this is on paper. But if it is, if this building, for example, if this property is behind some fence, then we won't be able to see it. We try to insist, but it takes time, and as I said, we don't have much time of this, because as I said in the very beginning, you can instantly transfer money from one bank account to another. That is why we are streamlining regulation in this sphere. And currently, everyone agrees that the Bank of Russia should have these wider authorities, but still, it takes place. In terms of expanding rights and authorities of the Bank of Russia, I should also stress a wider right to give a motivated opinion. If we look at the international experience, and I would like to hear what our international colleagues think about it, regulators in other countries, they do have this right to get a motivated professional judgment, and it concerns property assessment, it concerns interrelations between organizations and other things. And we have to link everything to our regulatory system. And sometimes banks who do not agree with our opinion, they file a claim and they provide lots of reports and auditors' reports to the court, and very often they win and we lose. So we have been done a lot in order to get this right to have our motivated professional opinion, and we'll be granted this right starting from January next year, but it will be sort of limited. So we will be able to do it only to demonstrate a link between the loan holder and the bank or its affiliated entities. It's just a minor thing, but it is absolutely compulsory. And why do we need it? Analysis of those 86 licenses that have been called away last year. In many cases, the bad quality of loan portfolio was due to the fact that the loans were provided to companies or people who were somehow related to the owners of this bank. Formally, there were no evidence, and it was very hard to prove it, and we cannot demonstrate it using the documents. But through various economic links and through this analysis, our bank will be able to produce our opinion on it, and we will require that if some companies have a certain interest and relations with the owners of the bank, with the, this lending organization, then no loan should be provided. Then we expand requirements in terms of responsibilities of the shareholders of banks. In various international jurisdictions, we see that there's stronger regulation of this. Currently, we only can request bank shareholders to cancel a deal if this transaction caused certain damage, or if the Bank of Russia regulations are violated by this transaction. If this hasn't been done, then for within 45 days we can call away the vote of the shareholder. So this is the only thing we can do to influence, to have an impact on shareholders. So these are major things which we envisage will help us to reduce, to crack the financial crimes. And if there are any questions, I will be happy to respond. Thank you. Dear colleagues, do you have any questions? I have a question. You have touched upon a very interesting topic. Could you please tell us, how do you consider the future of the banking sector? Because this is very important. So right now, auditors, they sort of not responsible at all for the opinions and reports, because I have seen many times reports when they assessed some level 0 construction, but there was nothing really. There was just a vacant site, and there was it was assessed costing several million US dollars, and that was signed by international companies. We are moving away from the Russian accounting standards, and we are moving towards international financial standards, and so far nothing better has been developed, and these are best practices, and we are going to play in the same field with the rest of the world. My question is, what do you think? You insist that your authorities should expand, your mandate should expand, but we all understand that this shouldn't be something fictional. In the end, we have to meet in court, and we will be discussing that, so there's nothing else. Only court decisions have the final power. Is it possible to develop certain regulations so that they are not contradictory to the Russian accounting standards, because otherwise all banks will be in quite a difficult situation?
Well, the internationally accepted accounting principle standards are in fact just guiding principles, which is different from the Russian accounting standards. I'm now referring to the BAL principles and the BAL normative base. The foreign regulatory components are based upon certain principles, and then we have the question of acting up to the principle or not, whether there is a fair application of a principle or not. You can use the international accounting principles to assess some assets, and you can do it in a fair way, or you may do it in an unfair way. So the subjective component is very important in all such processes. In foreign jurisdictions, the international accounting principles and the Basel principles work rather well, at least in some foreign jurisdictions. Yes, not in all of them, definitely. You are right. And those principles are confirmed by institutes. They are supported by institutes with well-established reputations. I'm referring to professional accountants, auditing, well-established auditors, and so on. In those countries where there are no such established institutes, so at least no generally accepted institutes, the number of offences is growing, and it will grow. So greater freedom in accounting, in finance, and own risk assessment may bring even larger risks. So we are going our own way. We are implementing all those principles, but we are trying to make a very detailed interpretation of their possible applications. Let me give you a simple example. We are not just translating the capital adequacy Basel principles into the Russian language, which is normally done in other jurisdictions. Normally they just translate the Basel documents, they give it over to banks and say, here goes. This is what you have to apply. But we detail it out to a great extent. We give the number of accounts, sub-accounts, and even parts of sub-accounts. We prescribe all that. And then it greatly helps us when we meet in court to have a good body of evidence. Thank you very much for your intervention. If we don't have any further questions, then this is a very good point to give the floor to Jonathan Kelly.
That have strict, concrete, and very historically, I don't know, evaluated standards of financial activity. Jonathan Kelly, partner Cleary Gottlieb Still.
Jonathan Kelly is partner of the London office of Cleary Gottlieb Steen and Hamilton LLC, to be highly recommended by our British colleagues as one of the top financial litigators of the United Kingdom. Jonathan, the floor is yours, please.
Does that work?
No, the microphone is obviously not on.
Кто-то включил. Okay. Oh, that's better. Thank you very much, Natalya, and good morning, ladies and gentlemen. It's a tremendous privilege to be invited to speak to you today, and I found our previous speakers very interesting in their comments. And what I would like to do is, as I make a few remarks about the international perspective, just to pick up on some of the points that Vasily and Natalya and Gandolfo have made. What I'd like to do, first of all, is just make a few introductory remarks about what we see on the international stage in terms of financial crime and the pursuit and enforcement activities against financial crime. Then I'd like to try and explain why I think we have reached where we are at the moment. And finally, to conclude with just a few short remarks on what the future might hold. First of all, let me just pick up on a point that both Natalya and Gandolfo made, which is that the interconnection between jurisdictions and the complexity of the particularly the financial world, as well as the corporate world that we all live in now, has meant that the world has become flat. And by flat, what I mean is that in this interconnected series of activities, not only business, but financial enforcement, criminal enforcement, has become increasingly interconnected. And you see that in the way in which regulators reach out of their own jurisdictions into other jurisdictions, and in the way in which enforcement bodies, the Department of Justice or the FBI or the Serious Fraud Office, as well as others in other countries, behave. And as Vasily mentioned, there's been increased focus on the banking sector, the financial sector, and we certainly see that in the UK and the US, and much of what I'm going to say is directed at the financial sector. And that is partly because of the nature of the activity that Vasily highlighted, but also because of the international dimension to these activities. And so you've had really four principal areas of financial enforcement coming to the top of the agenda over the last decade, the last few years to a decade. The first was anti-bribery and corruption, and I'll come back to that. The second has been economic sanctions, particularly in relation to Libya, Iran, North Korea, and associated issues around those sanctions. The third has been money laundering, which we've talked about and heard about. You know, money laundering really has been one of those issues that has been at a forensic and administrative level for many, many years, but it has bitten a large number of major financial institutions where they have failed to address money laundering effectively. And finally, as I think Natalya mentioned in her opening remarks, tax evasion. So the first 2 points, the world is flat, and you have these particular investigations and offences that are drawing great scrutiny. The third point that I'd like to make is that we've seen a combination of the new and the old in terms of statutory power and force. The old, for these purposes, has particularly been the Foreign Corrupt Practices Act in the United States, which was actually passed into force in 1973, would you believe? I mean, 40 years ago, in the wake of the Richard Nixon Watergate scandal, and promptly sank beneath the waves, never to be seen again for 1 or 2 decades. And I'll come back to that in a second, but it has now resurfaced with a vengeance over the last 10 years. The younger brother, or the son perhaps, of the FCPA is the UK Bribery Act, which many of you may have heard about or been familiar with. And that was passed in 2011 and was a direct reaction of the UK government's embarrassment and shame, in fact, at the poverty of UK anti-corruption legislation and anti-bribery efforts. The government decided that it was just too embarrassed any longer to go onto the international stage without having a proper anti-bribery statute in place. And some would say that it may have gone a bit too far, but we can talk about that in a second. You have expansive long-arm jurisdictions being exercised by a number of these bodies, whether it's under the Bribery Act or the FCPA, and that is a factor that has created a lot of profile, but also a lot of tension. And some of the tools that the regulators, both criminal and financial regulators, have at their disposal have poured petrol on the fire in terms of this profile. One of the most controversial in recent times is the Whistleblower Program that the SEC introduced just in the last 3 or 4 years. And that program basically gives whistleblowers a slice of the action. They are entitled to some element of a fine or a penalty that is imposed on a company. So you can imagine the effect, the incentivization effect that has. That explains why one individual in particular tried so hard to persuade the authorities that he was the whistleblower for Madoff, because Madoff, the ultimate penalty was something in the area of the loss was $75 billion. So if he had had a 20 or 30% whistleblower fee for that, he wouldn't have had to go back to work again, that's for sure. And the final point, just by way of introduction, and this picks up on one of the points that Vasily made, is that you have a convergence of the political and regulatory will to promote transparency internationally and to eliminate what have been traditional safe harbors. As Natalya said in her opening remarks, as recently as the 1990s, Swiss banking secrecy and confidentiality was taken for granted. You would never even question it. And that has been blown apart by particularly the US investigations into HSBC, into Credit Suisse, into UBS, into Bank Leumi. And you have fines ranging from $780 million in 2009 for UBS, ramping up to $2.6 billion for Credit Suisse in 2014. So you see a massive increase in the extent of the fines. That was in relation to bank secrecy and particularly tax evasion. I mentioned money laundering as one of my other factors. HSBC found out, of course, to its cost with the Mexico money laundering scandal, where there were concerns that it was actually laundering the proceeds from Mexican drug cartels, and was fined $2 billion in 2012. In terms of sanctions, BNP Paribas was fined $8 billion in 2014 for breach of sanctions and activities stretching back to the early noughties and the 90s. So you see a dramatic picture in terms of the international pursuit and enforcement against financial crime. And one asks the question, why now? What has happened in the last 5 to 10 years to encourage this this spike in activity. I think there are probably 4 principal reasons to my mind. First of all, following the credit crisis, there has been a significant shift in the balance of power from banks and institutions on the one hand to government regulators, to central banks, and to other enforcement agencies on the other. And now that may sound strange because the government should always be in charge, the enforcement agency should always be in charge. But one only has to look at the situation with the Swiss banks to see that the laissez-faire status quo that had applied up until the 1990s allowed the establishment of confidentiality and secrecy as a primary principle of Swiss bank business to be unchallenged. Now, that's fine for legitimate purposes where someone wants to put their wealth into a bank account to avoid kidnap risk or simply for conventional privacy reasons. But of course it also enabled those who wanted to use banks for other nefarious purposes to hide behind those walls. So that shift in power that has happened not only in financial regulation but has extended to financial crime has been a major factor. I mentioned the renewed focus on tackling corruption. Just to give you some sense of how the FCPA has been revitalized over the last 10 years, I asked one of my colleagues in New York last night to send me the figures from 2002 to 2012-14. In 2002, there were 2 cases brought under the FCPA. In 2010, there were 20 cases. So there was a 10-fold increase of cases just in 1 decade. The amount of fines is even more staggering in the level of increase. In 2002, there was only $2.7 million in fines imposed for FCPA breaches. So virtually nothing by regulatory standards. It was almost as if the dog was asleep rather than barking. By 2014, the dog had woken up good and proper, and the fines had gone from 2.7 million up to $1.56 billion, spread across 15 to 20 different infractions. I talked about the Bribery Act briefly. The Bribery Act has sometimes been called the FCPA on steroids. It has tremendous international reach. You only have to have some indirect connection with the UK to be brought into its remit. There are investigations of activities in China, with Glaxo, Rolls-Royce in Indonesia, ENRC in Kazakhstan, all over the world. It is a UK statute, but its extraterritorial application is almost second to none. Following up on the Bribery Act, the UK government announced in December of last year that they weren't just satisfied with the statute, they were going to introduce an entire anti-corruption plan. And that would go from the most basic of principles to such as avoiding juries being tampered with or corrupted by defendants, all the way through to international cooperation with other agencies in the pursuit of corruption. And I'll come back to a case study about that in a second. And finally, you have a series of bodies, for example, Transparency International, Global Witness, other NGOs, who have made corruption, particularly in Africa, but also in Asia and in Latin America, a major source of focus. And so what you end up with is a combination of economic sanctions that have increased with global political turbulence, bringing the breach of sanctions to the fore, and legacy issues that have a very long tail in terms of being resolved. For example, the HSBC Swiss private bank episode was all triggered by the leak of about 100,000 bank accounts by Hervé Falcioni in 2010. And here we are in 2015, still feeling the effects of that. How does all this happen in practice? Let me give you one quick case study of a case that we've been involved in, just to give you an example of the international operation of what I've been describing. So, Global Witness, in conjunction with George Soros, the well-known financier, took a particular interest in Guinea. Guinea is one of the poorest countries in the world. It's in West Africa. It has a huge iron ore mine deposit, the best iron ore deposit in the world, apparently, but it is untapped. And the mining licenses for this deposit are very valuable. And under the previous two governments ago, there were allegations that the mining licenses had been basically sold to a company in return for bribes to a government official. And the government official happened to be the fourth wife of the then president, Alpha Condé. And these allegations rumbled around for a number of years and then came to the fore quite recently. What was particularly unusual about these alleged bribes is that they were recorded in contracts. I'm not a specialist in how to bribe people, but I certainly would never write it down in a contract. But the fourth wife of President Condé thought that she might be diddled out of her bribe money, so she recorded it and had the contracts notarized by Guinean lawyers, which is one of the more bizarre aspects. It gets more bizarre, I promise you. Of course, some years later, when these amounts of money in the low millions of dollars threatened to jeopardize the holder of the mining licenses, efforts were made to retrieve these contracts and destroy them. And so what started in Guinea moved to Paris. A Frenchman by the name of Sillin was dispatched from Paris to the United States, where the recipient of the bribes now lived. And his task was to recover these contracts and burn them. And we all know, we know all of this because, unfortunately for him, the individual recipient of the bribes had become an FBI undercover witness. She had joined the witness protection program. And so all of her conversations with him were tape recorded. He was arrested, charged with obstruction of justice and other offences, and was sent to jail. And this was the poster child case for the DOJ and the FBI in 2014. Because what the US government wanted to demonstrate was that wherever there is corruption that somehow affects the United States, whether it is the use of dollars, whether it is where a witness might be, whether it is with, obviously, interference with any aspect of US justice, then they will pursue it very actively. And as I say, that case has become something of a poster child for the way in which countries like the US, the UK, are trying to lend their support to governments in Africa who want to move on from perhaps former regimes who may have been involved in corruption. So let me just conclude, as I said I would, with a look at what the future holds. I think it holds two broad trends. First of all, I think an increase in all of the issues that I've been talking about in the question of sanctions. I think corruption will remain very high up the agenda, and the use of essentially financial regulatory mechanisms to pursue crime. One of those, which I was very interested to hear Vasily mention in the Russian context, but it's happening in the UK and it's happening in the US, is the extension of criminal liability to senior management of banks for failure on the part of the banks. And that is that is a child that is born directly out of the credit crunch, because the public and the political will has been so overwhelming to punish bankers, senior managers who would get bonuses when it was sunny and who would get bonuses or perhaps just leave the bank when it was raining. And that is no longer considered acceptable. The other area which, if I had to make a prediction for international criminalization in the financial sector, is in competition and antitrust. We have seen the international scandals around LIBOR and around the foreign exchange manipulation to have extended across countless countries in the world. And numerous currencies have been affected. There have been significant fines for regulatory and managerial breaches by the banks involved. But we have seen for the first time, certainly in my 30-year career, the use of competition fines against institutions. And increasingly, competition or antitrust legislation criminalizes cartel behavior on the part of individuals, as well as allowing institutions to be fined. And I think we will see much more activity in that area, with individuals being pursued for anti-competitive behavior, not simply or not just fraud, market manipulation, insider dealing, and those other traditional matters that I've talked about. So thank you very much for listening so intently. I'd be very happy to take questions or to...
Please use the microphone. When the speaker is not using a microphone, there's no translation. Okay, there's a brief remark. Okay, and now we are moving over to financial intelligence. Pavel Valerovich Levadny, State Secretary and Deputy Director of the Federal Financial Monitoring Service. Thank you very much. For me, it is a great honor, and at the same time, it is a serious difficulty to speak after such highly qualified speakers who raised all these most important issues. I would agree with everyone who was speaking before me. As for the existing trends in terms of the challenges the financial sector is facing, the financial sector plays a dominant role above the real sector in the economy. We can have a look at the natural resources market. And now the oil prices have nothing to do with supply and demand, and have nothing to do with interests of the consumers. So all this is determined by stock manipulation and the cost of stock. And unfortunately, this is a reality of the current day. And the whole real sector is affected by this. And we can speak now about two trends. On the one hand, the state, which has well-developed financial mechanisms, they try to preserve their leading position, and they use, and they speak about it, they use their financial opportunities, and including financial intelligence and financial control, as a weapon in financial wars. And countries with developed industry, both manufacturing and production, but if they sort of lag behind in their financial sector, they try to oppose, to stand against big corporations within BRICS, for example, association, and they try to protect their national jurisdictions using the principle of national sovereignty. And we have heard a lot from our British partner in terms of the United States, who was fighting Paribas for servicing Iranian companies, and that was even before the United Nations introduced sanctions. So the question is how far regulators of certain jurisdictions can reach. Firstly, they say that they introduce actions when there are international sanctions. For example, the UN sanctions against certain countries. But this sanction mechanism is developing, and some countries use economic sanctions against residents of other countries for actions that they perceive, but it is not acknowledged by the international authorities, by the United Nations, for example, for actions which are not viewed as an offense. So the question is whether these jurisdictions can take actions against people against whom there are personal sanctions. And the question is whether there will be bilateral measures. For example, when there are transactions in rubles or in yuan, or Kazakhstan in tenge, and if bribes are taken and given in these currencies. But then I believe we might face a war of jurisdictions. So if we use this exterritorial principle in this complicated area of financial market, then there will be real butchery. There will be a slaughter of everyone against everyone, and criminal institutions and anti-money laundering institutions should develop, and there should be some agreements, and decisions should be taken on an above national level. Now, speaking about financial monitoring on the principles of Financial Action Task Force. This is really the only anti-criminal topic where we observe a universal consensus. This consensus exists both in the area of anti-corruption crimes and war crimes. But when we speak about money laundering, here we see that politics is not prevailing. And also, there are well-developed international instruments. They are not part of some international regulation, but these mechanisms are approved by various countries. And these are, for example, standards of this Financial Action Task Force. And we see that there are real outcomes of this fruitful cooperation on this ground when everyone has access to these actions. So the universal nature of this mechanism, on the one hand, provides for ensuring international interests. On the other hand, it protects national jurisdictions. What are major problems the Russian Federation and the international community face in the area of evasion and law violation, then a distribution of mass destruction weapons and all other areas? These issues may be resolved on a timely basis only if we use some efficient notion of economic transparency. When there is a clarity about beneficiaries and beneficiary owners of companies, then it becomes easier. For Russia, it is a way we have stepped upon. We are not using the pathway under the fourth European Directive. We are not developing an open registry of beneficiary owners because this list, as we expect, will be not full, because there may be some fictitious beneficiaries as well. So each aspect of this work should be, analyzed how it is performed in practice. Maybe in the near future we will follow the European targets. In 2013, all banks had to determine beneficiary owners of all customers. And although we all understand the importance of this, but most banks they cannot have private detective agencies, and we decided to take some additional steps. In the civil code now there is a notion of a person who controls the operation of a company. And now we are discussing and preparing a normative act where there will be a requirement that all companies need to have information about their beneficiary owners. And this is important, for example, for stock companies, for example. And there's a requirement that they need to provide this information about the full structure of their organization to the authorities. In such a way, the companies, through the compliance mechanism and using the principles of appropriate work, so all banks will be able to obtain this information and verify it, and they will see whether the stated people are real beneficiary owners. All this will give us a clear picture of the ownership structure, and this includes international companies for which some Russian companies work. I heard many times from the United States representatives at various FATF meetings that if we open up all the names of beneficiary owners, then we will actually see the world economy in ruins. Yeah, I understand why is that and why the leading jurisdictions are opposing this process, but this doesn't mean that we should stop. We still believe it is one of our priorities. Now about liability for financial and prosecution for financial crimes. At the beginning of the 2000, confiscation of property, so this requirement was taken out of our regulation. So now we have introduced it again. There is a way to confiscate the property which was gained through some illegal actions, and in practice we see some paradoxical cases when people are imprisoned and for quite a long time, but these people still possess all the property they had. Again, we have introduced a new measure in the criminal code. There's a number of offences for which confiscation can be used, and legalized income also is subject to this confiscation. So law enforcement bodies should view such laundered assets. They are viewed as something illegal, and but sometimes it is hard to prove it, because the Russian legislation, unlike the Anglo-Saxon law states, is quite formalized, and all evidence should be of formal nature. In practice, it is not typical when you analyze the actual facts, but not formal proofs. And we are working, and we try to modify this, and we want to expand the types of evidence that might be used in court, and we hope that we will manage, and illegally obtained properties will be confiscated. And we have already heard today that bank management liability is extremely important for establishment of certain conditions. I'm not speaking about schemes, but conditions for some illegal actions. Okay, so if there's some shadow actions, then it means that the top management provided conditions for this. So there can be, semi-criminal edge when there's no clear, border. There are fuzzy edges. In the modern world, it's very rare when the money is laundered, and used directly by the persons who do that. And through all those actions that were taken to sanitize our banking system, we don't see some really bad cases now. But there's still a lot of work that should be done. There's a difficulty with proving the intention. And when we're speaking about a certain crime, we need to be able to prove that subjectively this person, top management of the bank, was involved or was aware of it. And we see this in practice. So we need to adjust our regulation, our laws, criminal laws, and we will be speaking about criminal liability of top managers. If, for example, there are favorable conditions for money laundering, so when a license is called away, we will try to prevent these top managers to join another bank and provide their advisory services to some other criminals. So we hope we will increase liability of managers of banks, and this will mitigate risks in this sphere. At the same time, we need to beat money laundering schemes, and there should be compliance control measures. We need to work with customers. We need to determine their beneficiary owners. We need to analyze all transactions, because without this, nothing is possible, because this is the only sphere where financial organizations are on the front. And also, the unique feature of this anti-money laundering system is that this ensures fulfillment of goals important at the governmental level. Now, for example, in the United States, they use these mechanisms for international wars, and they try to influence other economies and jurisdiction. But in Russia, it is supporting the local development and development of our economy. And one of the tasks formulated by the president of Russia is to prevent a single ruble being spent in vain or in some inappropriate way. and all the bodies that monitor budget expenditures and allocation. So they are responsible for this sphere, and they're responsible for efficient use of these funds. And this is one of the characteristic features of our financial intelligence and other services. Thank you very much for your attention. Thank you for this interesting presentation. I understand that we have so many other things we may discuss, but I should say that actually there's no time. I remember that I promised questions, so we have time for one question. I believe you had a question, right? Yes, I promised that we were going to have a question. So.
Thank you very much for the excellent four presentations. I really enjoyed all different aspects. I have very short questions from all the four speakers. From the first speaker, you're talking about, among other things, about the EU directives. I think I come into the third or fourth generation on that. Now, does it have any kind of extraterritorial effects, this European law? For example, in relation to Russia? And is it possible, for example, if Russia didn't comply with this anti-money laundering legislation, are we going to face another sanction mechanism against Russia? That is one. The second question is to the
Я не могу не прокомментировать.
I can't help but comment right now. Russia is complying with the anti-money laundering legislation, which is recognized by Manuel and FATF. So I believe this question is a provocation, and please don't ask any such questions anymore. Well, there is a novel law, and Russia does have a very good record with FATF, which makes it a bit different from some other European countries, to put it very frankly.
When I come to the interesting presentation by the Deputy Governor, you gave different grounds on where fines could be imposed, imprisonment. What are the grounds on which a banking license could be withdrawn? There has to be a very serious breach of the banking law. Then the third speaker, it was a hypothetical question now. UK is now going to have a referendum on its future of the European Union, and most of the legislation you have, they're based from the EU financial crimes, for example, anti-money laundering, etc. By any chance, already the Bank of England, I think it's leaked in the email, they are preparing for UK outside the EU. Now, UK have adopted a lot of legislation. Now some are even pending, I think, financial turnover tax, etc. So if by any chance UK leaves, what happens to all this legislation which is there? Especially now EU's sanction on Russia, and how is UK going to handle that? And the last speaker also, you're talking about bribery, corruption. Of course, it's political element. And then you said there's if I got it correct, anti-money laundering is not so much politics. But to my opinion, I think all these three issues are very much interconnected, because bribery, dirty money goes into money laundering. Now, I think UK is, United States, I think you all would have read about it, FIFA officials under investigation. Russia has, of course, expressed its reservations about that. Now, there it's, I think, from what I read in the morning, it involves all three elements: bribery, corruption, and anti-money laundering. So I just look forward to your views. Thank you.
Это работает. Вопрос.
Well, let me take the question with regard to whether or not the banks have to seriously break the laws. to get a license called off as compared to other countries. I'm not going to give you all the provisions of the relevant legislation, which may have a bank give up its license because there may be different types of crime. So we can separate the cases into two parts. We can talk about economic offences and, secondly, it's offences related to money laundering. So, as regards economic offences, the bank should have under 2% of capital adequacy, and this is the way we are taking. We analyze the qualities of a bank's assets, and we check whether they comply with provisions requirements and whether or not they decrease the capital adequacy. And that is basically in line with the norms of foreign legislations. So to have a bank's license called off on economic grounds, the bank should be doing poorly economically. Now, with regard to anti-money laundering laws, some recent amendments have been introduced into the Russian laws, and the regulation is now very tight. Simplifying the explanation, I can say that a bank has to make just 2 offences, like fail to submit reports just twice under the anti-money laundering law, and that is enough for the bank's license to be cancelled. So the Russian new law is now very tight, and we are very attentive about its enforcement.
There'll be enabling legislation to adopt into English law any directives that are required. I don't think there'll be a cliff face that will fall off. That would be rather embarrassing for the government, but hopefully they'll be well prepared for it.
Да, у меня, да, я поспешил отдать микрофон.
Sorry, I was too fast to give away the microphone. I have to add with regard to economic grounds of calling off a bank's license. If a bank fails to pay what is due to its clients within 14 days, then the license shall be called off, and the central bank must do it in 14 days. This is as regards the deadline for the regulator's response upon any offences. Ladies and gentlemen, thank you very much. We must let our speakers go because they are expected to take part in some other panel discussions. Thank you very much for attending this session in spite of the difficult night yesterday.